Here in Queensland, mental illness is a condition characterised by a clinically significant disturbance of thought, mood, perception, or memory. With this Act, there is a set of criteria that must be met. That the person appears to have a mental illness requires immediate assessment, and assessment can properly be made at an authorised mental health service. A suspected mental illness appears to require someone to judge if their disturbed mentality is clinically significant. We believe that Odessa's hypoglycemic event was a clinically significant disturbance of perception and thought due to her blurred vision and inability to control the car. Given the supplied information, it is difficult to ascertain if her mood and memory are clinically disturbed. Patients who suffer a hypo recover very well after treatment. This indicates that this change in mentality is only transient and a state secondary to her underlying condition. Post-reassessment, she no longer satisfies the criteria for a mentally ill person. New South Wales' legal definition for a mental illness is to have a condition that seriously impairs either temporarily or permanently your mental function, which is shown by you exhibiting particular symptoms and being at risk of harming yourself or other people. The ACT, NT, Tasmania and WA have a similar legal definition. These states all include the word serious rather than clinically significant. It is difficult to differentiate what mental conditions are serious and what are just moderate, opening up interpretations of these legal definitions to ambiguity. SA's legal definition of mental illness is any illness or disorder of the mind, which is broad and ambiguous. Victoria's focuses on the power to admit and detain an involuntary patient who appears to be mentally ill. The remainder is very similar to Queensland. We will be investigating this case further under the state laws of Queensland. A person must not be considered to have a mental illness if they present with any of the following. There is no information provided in this Act that suggests a hypoglycemic episode can prevent Odessa from being classified as mentally ill in the transient circumstances of this scene. The Mental Health Acts of all other Australian states are very similar in this respect.
Compared to the Mental Health Acts, capacity essentially determines whether the patient is capable of understanding the purpose and nature of the treatment, as well as the risks and consequences associated with it. Queensland's guardianship system assumes that a person has the capacity to make a decision until it can be shown that they do not. But determining capacity is a subjective matter and often comes down to a paramedic's judgment call. Capacity can be a transient state, given the fluctuations in a patient's condition. When Odessa first suffered symptoms, her vision was blurry with an altered GCS level. She did not have capacity at this time. After treatment, she is able to understand its purpose, but she still does not have full capacity as she fails to interpret the consequences associated with another potential hypo episode. In this instance, she fails to understand the gravity of her decision to say and risks associated. We believe Odessa does not have a valid refusal for consent, given that she still lacks the capacity to make a fully informed decision on her future treatment and transport. Therefore, we need to provide treatment in line with relevant CPGs. The age of majority in Australia is 18 years old, but Odessa is 10 days away from that birthday and has virtually achieved the autonomy and decision-making power of an adult. It is stated that there is a period before the age of majority is reached, that a child can consent to certain decisions and procedures, and that the law is unclear in this area. It depends on the relevant circumstances. Although she lacks capacity, her age is not a determining factor in regards to whether she can make decisions for herself for the refusal of transport.
The deprivation of liberty is defined as the unlawfully confining or detaining of another in any place against the other person's will, or otherwise unlawfully depriving another of the other person's personal liberty. However, as Odessa post-glucose administration was classified by the paramedics as a patient who does not present a mental illness, they are not entitled to deprive her of her liberty. Healthcare providers must use the minimal amount of force to carry out healthcare, so if Prakash chooses to detain Odessa, his actions are unjust and forms unacceptable conduct. We believe that the paramedics acted in an ethical manner, as after reassessing Odessa post-treatment, agreed that leaving her on the road under no supervision and with no food would lead to negative and dangerous consequences. Furthermore, taking her to hospital for medical assessment or at home under the supervision of her parents was the right thing to do. An EEO gives the authority to detain and transport a person experiencing a mental illness. Detaining a person is a serious and forceful action since you remove their freedom. The following stringent criteria must be met to use an EEO. Does the person have a mental illness? And because of this, is there an imminent risk of significant physical harm being sustained by the person or someone else? The rest are on screen. We have determined that Odessa is not currently mentally ill, so fails the first assessment criteria, thus voiding and invalidating the lawful use of an EEO. She is also involuntary to the idea of transport and does not meet the criteria to be detained for emergency treatment as an involuntary patient. If we were to enforce an EEO, we may be found guilty of misdemeanor and liable to imprisonment for 2 years.
As paramedics, we have the power to take any reasonable measures to protect persons from any potential danger, which is for paramedics to leave the scene and Odessa having another more significant hypo episode. The consequences can be as severe as seizures or a coma, which are life-threatening. As Odessa is lacking capacity, we will need to call one of her legal guardians that have the authority to provide consent, most likely her parents. The two options we'll provide to the legal guardians are listed on screen. We are also advocating for Odessa as the patient and express to the parents her concerns with running the errand and leaving her car to be towed. In this way, they can make arrangements to ensure Odessa's concerns are alleviated. If no one can help, a road maintenance company or the QPS can be called to arrange someone to stay with the vehicle until collection. Odessa's health is the priority.
Here comes the sun, doo-doo. Here comes the sun, I say it's alright.